Good afternoon. My name is Attorney Tanika Thompson Mungo, and I am the managing attorney with the Thompson Mungo firm. You do have the opportunity here to ask questions and raise your hand. If you do have any questions, please let me know. Otherwise, I will save questions until the end of the presentation. If you could give me just a moment, let me get the PowerPoint loaded, and then we'll go on ahead and get started. Alrighty, I hope everyone can see my screen just fine. So thank you once again for joining us today to discuss estate planning. Let me go back to the starting of my presentation here. So the title of our discussion today is Protect Your Family, Estate Planning Basics. There are certain things that we do need to know to make sure that we are protecting our family members and also ourselves, just in the event that we either become incapacitated or even pass away. So thank you once again. Just to let you know, my firm is the Thompson Mungo firm, and we are located in McDonough, Georgia. Our office is on 390 Racetrack Road, and our office number is 678-855-6002. So just to give you a bit about of our information about our firm, and what you'll learn today is that you're going to learn a little bit about the estate planning process, and we're going to maybe discuss a few things that you may think about in making decisions that relate to not only yourself, but your family. Additionally, we'll also discuss how to create a plan for your family and your assets, and also planning for medical contingencies and things of that nature. You know, things that may not necessarily always be top of mind for everyone because life is so busy and there's so much going on. So I just want to make sure that we at least touch on a number of different things that will at least raise your awareness as to certain things that you should keep in mind. So one thing that is important in estate planning is to plan for your family. No matter what your family looks like, whether you're married, you're single, a single parent, or what have you, it's still important to have a plan in place, just so that you can make sure that your wishes are carried out no matter what. In the event that you pass away, and also if you have kids, you want to make sure that they're protected as well. Um, if you do have children that are under 18, they're minors. So they are not able to care for themselves in the way that you would expect for them to. So it would be wonderful to at least nominate or name someone to be a legal guardian for them in the event that something were to happen to you. Even if you're a married couple, it's still very much so important to have someone named that can be responsible for your children in the event that you are not able to be there to take care of them. Um, Unthinkable things can happen in life all the time, and we don't want to think that things like that will happen, but let's just always try to be as prepared as we can, to make sure that in the event anything happens, our children and our family will be protected. Now, there are certain things that you would like to think about when considering a guardian for a minor child. So, certain things that would be important for you to think about is whether or not the person that you are intending on nominating as a guardian is willing to raise your child. You know, are they willing to accept that responsibility? Is that person an adult, and are they considered an adult in your state? So in Georgia, you would need someone that's at least 18. Also, do your children or your child know, like, and respect or even love this person that you're nominating to be a guardian for them? Also, is this person responsible and mature enough to manage the responsibility of raising a child or even raising your child, most importantly? Does this person have any health concerns? Are they capable physically of taking care of your children? Um, does this person share your beliefs, your religious beliefs, your values that they will continue to instill them in your child or children? Does this person have a living space to accommodate additional people and children? And also, does this person live near my children's family members? So will it be a matter of uprooting your child and moving them to another state or another part of the country where they're now going to be disconnected from what is familiar for them? That those are things that you definitely want to keep in mind and take into consideration when you're making a decision as it relates to naming a guardian for your child. Another consideration is whether or not your children or your child has special needs. If you have special needs children, they require additional considerations when it comes to deciding whether or not to nominate someone as a guardian for them. You want to make sure that you can take into consideration that this particular individual will be able to meet the requirements to keep up with doctor's appointments and also being able to maintain the demands that this particular child may have, whether it is health related or even just emotional related. So, can they accommodate or even handle those responsibilities that would be needed for your child? Also, if you have a special needs child, you have to be very considerate of passing certain assets depending on whether or not they are receiving certain benefits. So if you do have a special needs child that receives benefits or certain benefits based on income, you don't want to gift them anything or give them a large sum of anything that would result in them losing their benefits. So those are certain things that you definitely want to take into consideration if you do have a special needs child or care for someone that has special needs. So those are other things just to keep in mind. Additionally, um, you want to make sure that when if you do pass away, um, that you at least protect whatever it is that you have that's going to be passed down to your children. So granted, in this state, legally minors are under the age of 18 and they cannot own property or assets. So if they were to inherit certain lump sums or certain assets, they would need a guardian or conservator. In the state of Georgia, they need a conservator to be able to manage those assets for them. If there is not some plan in place, and that would have to go through the process of the probate court. That can be a very challenging, costly experience. So there are certain steps that you can take to be able to protect those assets for the children and to also ensure that they're not having to endure a long and drawn out court proceeding to make sure that those assets are protected for them. So in nominating a conservator or even having the assets included in a trust, you have someone that is already named that will be responsible for managing those assets and ensuring that it is protected for the benefit of your children and that they'll receive it at the appropriate time as designated in the trust itself. Next, one thing that you can consider is a testamentary trust. And this is a trust that is created upon the passing of an individual and via the preparation of a will. Granted, there are certain requirements that this document would need to meet to be able to accomplish this. So I would encourage you to be sure to at least contact an estate planning attorney that can assist you with getting this particular plan in place. So with a testamentary trust, you can stipulate specific terms as to when it is that your children or even your beneficiary will receive certain funds from an inheritance. For example, some parents can some parents wish to withhold their distributions to their children until they reach a certain age or they've accomplished a particular goal, whether it be graduating college or something to that extent. And this allows for you to prevent from the assets being distributed all at once automatically and being wasted because, sometimes younger individuals are not exactly the greatest stewards of their resources. So you in turn can then protect them from themselves by ensuring that they do not receive certain monies earlier than they need to, so that they can at least be responsible with their resources whenever they do receive them. Next, what if you do have an adult child? Even if you're a parent of adult children, having a will in place is so tremendously important, because you get the opportunity at that point in time to detail to them how it is that you would like for them to divide your assets, and it reduces the potential for there to be chaos in your family, or even conflict amongst your children and your family members in determining who's going to decide what, or who's going to handle whatever in your estate. So it is so important to have a will in place, just to make sure that it is clear as to what your wishes are. So it's not uncommon for adult siblings to disagree on parents' wishes once they pass away. It happens. We all have family members that may not have the best relationships. So it is in the best interest to at least have a plan in place prior to, so that there is no confusion as to what your wishes are. What about complicated family situations? I mean, there are so many very diverse and dynamic family structures currently that it makes it very complicated when it comes to probate. And also, the laws have not necessarily evolved in every state, as it to actually reflect or recognize certain family structures. So those that have those very dynamic family structures, it's best to at least create a revocable living trust to ensure that things occur the way that you would like. And in that essence, you avoid having I guess, the involvement or the forcing of the state laws to dictate how it is that your assets are to be distributed at that time. It gives you greater control and the opportunity to truly dictate what it is that you would like to happen, or even to give greater guidance as to the distribution of your assets at the time of your passing, if your family is non-traditional or dynamic in comparison to what state laws have recognized more recently. Now, what exactly are your assets? So in the state of Georgia, so long as you own anything, you are considered, and you pass away, it's considered that you have an estate. So once you have anything, you can potentially probate. Now, is it worthwhile to probate everything? It depends. It depends on the types of assets that you have. So certain assets that are titled certain ways may need to be probated. Other assets that are titled other ways, they may not necessarily need to be probated. It just really and truly depends. So it is so important to at least gather a list of all of your assets, just so you can take an inventory and see what exactly it is that you own at the current moment, and then you can make a determination as to how you would like it distributed at the time of your death. It's just a great idea to definitely take account of what you have at that time. Next, another way that can be used to, I guess, generate wealth is through life insurance. Getting a irrevocable life insurance trust can be an efficient and effective way to leave behind what your family would lose with your passing. So, if someone were to pass away, that's a loss of income, that's a loss of support, that's a loss of a family member that was very much so a contributing member of our family. And having life insurance is a great way to ensure that we can at least provide that additional support if we're not able to be there to take care of our family members ourselves. Also, planning for medical contingencies. This is also so very tremendously important, especially in the current climate that we're living in dealing with COVID-19 and so many other illnesses. It's so important to plan for these things. So estate planning, a lot of people just typically think about estate planning mostly as, oh, I need to get myself a will prepared. And it's so much more than that. It is also incapacity planning, and also planning for individuals that may not necessarily have the voice to be able to plan for themselves. So it's so important to at least make these decisions in advance, and identify, who will make medical decisions on my behalf if I'm not able to do so? Who will be authorized to make financial decisions if I'm not able to make them for myself? Also, another thing to take into consideration, what are your medical wishes? So, if, for example, um, if you would be willing to accept certain treatments or not, it's something that needs to be documented so that those wishes can be honored if you're not able to verbally state those wishes on your own at the time that a particular treatment may be needed. So the next topic here is, what about powers of attorney? So a power of attorney is essentially a great opportunity for you to name an agent. So for example, with a healthcare power of attorney, you're naming someone who can make healthcare decisions on your behalf. And designating someone to make those kinds of decisions can provide relief to your family members who may not necessarily want that kind of responsibility or may not be capable. I think in a lot of cases, we would like to think that certain family members would be strong enough to be able to make those decisions, but a part of it is um, knowing the character of the individuals that you're selecting to serve in these roles and understanding whether or not they would be capable to manage those decisions under that kind of stress. So that is something to definitely take into consideration when deciding whom it is that you would name as a healthcare power of attorney. Also, as it relates to financial matters, you can name a financial power of attorney, and that person can be responsible for paying your bills or even making investment decisions, or even they can handle other financial matters for you. And powers of attorneys can be very broad or they can be very narrowly tailored. So it can be prepared to where that particular individual can only handle certain things, or it can only be used for one event. So, and it would terminate after the occurrence of that event. So it can be as broad or as narrow as you would like it. That is something that I would encourage you to discuss with your estate planning attorney so that you are clear on what exactly it is that you are granting and the kind of power that you're granting in executing this kind of document. So what about an executor? An executor is a personal representative that is named in a will to, they will perform the legal tasks that will be required once they're appointed by the probate court. So they will take on the responsibility of essentially settling your estate, which that may include either selling property, paying creditors, looking at medical records, and distributing your assets to the beneficiaries or the heirs at law. So it really is someone that will take on a huge responsibility to go on ahead and finalize all of the responsibilities with closing out everything that was related to you, that being credit cards and everything like that. So this is a really, really important aspect when deciding to nominate someone as an executor. You have to select someone that you like, and you trust, and emphasis on trust. The executor of your will is a very, very tremendously important role, and you want to be careful in considering whom it is that you'll name to serve in that role. This person should be someone who can act responsibly on behalf of you and also can communicate with the beneficiaries that you've named in your will. You can also name someone as an executor that may be your family. It could be a family friend. It's a very, very important job. So it can even be an attorney, an accountant, a bank, or even a trust company. So it's something that you definitely want to put careful thought into, just to ensure that your business is conducted correctly and efficiently upon your death, and that there are no loose ends just hanging around even once it gets completed. Another thing is to name at least one younger successor. I know a lot of folks, when they name either a personal representative for their estate or even a trustee for their trust, they typically name individuals that are closer in age to them or more familiar with them, but it's a good idea to at least list someone that is younger so that in the event if any of your other trustees or even your personal representative is not able to act, you have someone else that is younger and can then continue on the duties of maintaining that particular trust or even serving in the role as the personal representative and to ensure that everything is completed in the way that you would like for it to be completed. It's just a matter of having quote unquote a backup plan. So think of it as such and nothing more than that, just making sure that you have enough individuals listed that if one is not able to, or they have, God forbid, passed away, that you have alternates that are able and also willing to serve. And it's also a great idea to at least have a conversation with the individuals that you've named as the executor so that they're aware of that particular request of you and they're not blindsided by being named as the executor after once you pass away because it is a huge responsibility and you'd like for that person to be ready, willing, and prepared and able to serve in that role and to take on that responsibility. Location. Okay, this is something very, very, very important to think about as well. So when you're naming parties in your will, keep in mind that location doesn't necessarily have to be a factor. For example, your executor does not need to live nearby. As many of an executor's tasks, they can be completed wherever it is that they are. So please don't feel that you're limited in whom it is that you can name as an executor in your will just based on the fact that they may not live in the same state or the same geographic region as you. You can still accomplish a lot by naming an executor that even lives across the country. I even have clients that live in other states currently, and they are still very much so handling all of the business as it relates to handling an estate and doing it effectively and without any kind of problems, even in the middle of COVID. So it can be done. So, where to begin? Now, granted, we've discussed just a few documents in this presentation here today, and we may actually schedule some more presentations just to delve a little bit deeper into other estate planning documents that we encourage our clients to execute just to make sure that they protect all of their assets. But just to review a couple of them, um, at least with getting your planning documents in place, we recommend that you at least have a last will and testament, in some cases, a revocable living trust, at least a power of attorney, an advanced healthcare directive, and also a HIPAA authorization. At least a last will and testament, power of attorney, advanced healthcare directive, and HIPAA authorization. Now, just let me review the HIPAA authorization with you. It's such a very important document to have because if you're going to name someone as a healthcare agent, it is it would be prudent to at least give them the opportunity to have access to your medical records so that they can make an educated decision if they're going to make decisions related to your healthcare. So it is so very important to at least give them the access to be able to look at your medical records to and then convene with their doctors to make sure that they are knowledgeable and making educated decisions as it relates to healthcare. Another thing to keep in mind when you're naming someone as a healthcare agent, keep in mind religious beliefs and things of that nature. That is so important, just religious beliefs, because some people are willing to accept certain treatments while others are not. And understanding whether or not the person that you've named as your healthcare proxy or your healthcare agent is aware of your wishes, whether or not they align with their religious beliefs or not, is also still very important to think about when you're going to name someone as an agent on that document. So, last step. Um, in creating your estate planning, or at least getting your estate planning documents created, it's so important to remember the importance of keeping these documents up to date, So you want to go on ahead and get your estate planning done, understand where it is that you stand with your assets, and then contact an attorney to get that plan put in place. We can assist you here at the Thompson Mungo firm, but if you prefer to go with another firm, that's okay too. At the end of the day, we just want to ensure that our clients and even those in our community are put in contact with competent professionals that can help them to put the correct plan in place for them and for their families. Because, for example, you don't want, say, for example, you could created a will maybe about 10 or 15 years ago, and you just, you just haven't really thought about whether or not you should go on ahead and have it reviewed. But in that time, in that 10 and 15 years, you've had a couple additional kids. So if something were to happen to you and you pass away, then you may just have unintentionally disinherited your younger children who were not alive at the time that you prepared that last will. So it's so important to just make sure that your documents are up to date as much as possible, just to prevent certain things similar to what I just described happening in the future. So there are certain events in life that it should raise an eyebrow or even trigger you considering to get your estate planning documents redone or reviewed or amended. So certain life events such as a marriage, a divorce, having children, changing jobs, even retiring. So those particular events should at least trigger you thinking about, maybe I should at least revisit, review, and, at least update and look at my documents just to make sure that they are as current as possible, and that they're reflective of my true wishes of today. So another thing to keep in mind is that is also naming legal guardians, because relationships change. And if a relationship changes with someone that you've named as a legal guardian, it may be time to update those documents as well. So any life changes that occur, it's a good opportunity or the best opportunity to then update your documents to make sure that they are as current as possible. So either you can contact my office, or you can contact another estate planning attorney office in the area just to ensure that your documents are as up to date as possible. Please, 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 please steer away from DIY planning, because it can be more hazardous than helpful in some instances. I would encourage you to work with an experienced estate planning attorney just to make sure that your wishes are properly and legally stated in your documents, and also that it's truly reflective of what it is that you would like to occur. There are many details that must be handled when creating a valid legal document. And sometimes individuals may prepare these documents and make mistakes in preparing them, and it results in the complete opposite of what it is that they would like to happen. So I would definitely encourage you to be mindful that those things can happen. And just to prevent those things from happening, just at least consult with an experienced attorney that can assist you in the proper way, just to make sure that those things are reflective of your actual wishes. So thank you for joining us. I'm going to stop the slideshow presentation, and I'm going to go back to ask questions right now, because I was not able to view them at the moment while I was presenting. I do have a few members here in the presentation, and I do see a couple questions, and I will go on ahead and read them to you. Oh, excuse me. And this slideshow is taking up my entire screen here. So just to start, the first one here is, I don't have an estate plan in place currently. How do I go about getting started with that process? Okay. So with that particular question, it's a very simple process, is to take the first step. The first step is to actually contact an estate planning attorney just to see where it is that you stand and what you need to do next. During that consultation, your estate planning attorney will discuss with you what your goals may be and will identify how you can accomplish those goals in the future. So it's so very important to at least reach out to an estate planning attorney to have that conversation, just to make sure that you at least cover all of the aspects of your life that you may not be cognizant that are there that you may need to protect. So it's so important just to involve a professional to make sure that you don't overlook anything in that planning process. Okay, let's go to the next question here. Okay, I have children that are 5 and 6, and I'm a single parent. I don't, sorry, this question is written a little funny. I don't have a lot of family that's close to me, but I would like to name a guardian to protect them. Okay, this one is something that requires some additional thought due to the fact that having young children, you would like to identify individuals that are like-minded as yourself and even capable to be able to take care of your children in the event that you're not able to do so. So I would definitely encourage you to get your estate planning documents in place, just to make sure that in the event that you are incapacitated, or even in the event that you pass away, that someone is there to at least care for and protect your children if you're not able to do so on your own. Okay, to the next question here. Okay, here it is. I have a number of assets and I would like to protect them and make sure that they're not given to my children immediately. How would I go about planning for that? Okay, that's an excellent question. So in the event that you do have a number of assets and you would like to distribute them to certain beneficiaries, that be your children or even extended family members that you would like to receive those particular assets, you can most certainly create a revocable living trust, just to make sure that you have control over when and what they receive. It gives you greater autonomy or control, so you can dictate whether or not they receive it immediately or in a structured um, distribution. And in doing so, you can also protect them from themselves, because we do have, there are some families that have family members that are not necessarily great stewards of their resources, or they may suffer from different ailments, whether it's addiction, whether they have poor financial management skills. You can protect them from themselves by not giving them or allowing them to receive all of those funds at the same time, and ensuring that they'll receive it in a very structured distribution, so that they are not harmful to themselves and potentially harmful to others around them as well. So you can definitely, via a trust, create the opportunity, or at least create something that will protect them in the long run. Even though they may not necessarily understand it in that moment, they could hopefully understand it later and see the bigger picture. Okay, so I have another question here that was posted. It says, if you are a single parent, does guardianship legally pass to the non-custodial parent? What if the preference of the custodial parent for the child or children to go to another guardian upon death? Well, this question, and it's a two-part, so I'll start with this part first. This question is very complicated in that it depends on what, first of all, the court order says as it relates to custody of those children. So we'll default to that first. But in the instance where, say, for example, if you are a single parent, and say, for example, if you're a mother and father has not declared his rights in the state of Georgia, he does not legally have rights to those children. So this question can go either way. but it's definitely important to at least document it in either your will or even executing other documents, identifying whom it is that you would like to serve as a guardian for your children in the event that their other non-custodial parent is not able to take care of them at that time. And is this an agreement that needs to be made with the non-custodial parent for the children to go to the other guardian? It's something that can be made as an agreement. It can be, but I would advise you to at least consult with a estate planning attorney and also a family law attorney just to make sure, dependent on what the order as it relates to parenting, the parenting agreement, whatever that states first, because I'm not sure as to specifically the details in your particular question just to be able to answer it clearly. So I just give that very general answer just to let you know that you would need to, it's a little bit more complicated than just yes or no. And I do have another question as it relates to cost for these kinds of services. And it depends on what it is that you need. So these kinds of services, they can range. So having a simple will prepared can start around $750 and it can go upwards. It just depends on the level of planning that you would need. Anticipate if you're going to have a trust prepared, there are certain aspects of the trust preparation itself that takes place even after executing the documents. And that's sometimes an aspect of trust preparation that is sometimes overlooked by individuals when you have an attorney that will prepare this amazing trust for you and you forget to fund. A lot of individuals will forget to fund their trust, and funding is so important. Funding is like the most important, one of the most important parts of having a trust prepared, because you can pay all this money to have these trusts prepared, but if the assets are not included in the trust and they're still titled in your name personally, by the time you pass away, it's then the process of going through probate to either it, hopefully there is a pour over will that will allow those assets to be funded to the trust via the will itself. Um, but it can range for the cost to answer that question. It can start from around 750 to $800 to have just a basic will prepared, and it can run upwards of maybe $4,000 or $5,000 or even higher than that, depending on the kind of planning that you need. And just to mention, I know I discussed revocable living trusts. If you have an elderly parent or someone that is much older and they may eventually need care from a nursing facility or even receiving certain medical benefits like Medicaid and whatnot, it may be something to think about putting their assets in a Medicaid trust. It's so important to think about that look back period, because there is a 5-year look back period where Medicaid would actually look back just to see what assets that particular individual owned during that time. And that particular asset will be imputed to that person as income. So it's so very important to keep certain things in mind, that if you do the proper planning well in advance, you won't have to have the headache of having to do certain things later on in life just to make sure that certain assets are not lost or taken or squandered or wasted. So doing that, taking that little step of making the making your plans can be so tremendously helpful in the long run. I do have, let me see, any other questions here. I'm not sure, does anyone else have any other questions? And I do thank you all for joining us today and asking these questions. They're so very important. Oh, this is an awesome question. Um, as it relates to life insurance trusts, well, actually, just getting the policies in place is one thing, but then doing a trust is another. I would encourage you that if I'm so sorry, I read the question and did not read it to you well. The question is, what companies do you recommend to research about the insurance trust? I would encourage you first, just do a Google search. Do a Google search to learn about different insurance companies, even if it's a company that you work with. And if you have a vehicle or if you have a home, you have someone that you have a relationship with as an insurance agent, you can contact them and have that conversation first to learn about the insurance policies that they have and the different types of policies that they have, because they vary so very much these days that there is more flexibility to have a very hybrid kind of insurance policy that will be beneficial and still cost effective. And then establishing a life insurance trust to make sure that those particular funds, once they are received by the trust, that they are not counted as a part of your estate. And they're also protected for the intended beneficiaries that you've named in that particular life insurance trust. So I would encourage you to either, if not, do a search as it relates to those particular topics, contact an attorney so that you can at least do a consult just to get some additional information, because even meeting with an attorney to discuss it, and it gives you the opportunity to ask questions as they come to mind. And you can get a response and get some better insight and some greater insight into your particular situation and how impactful having that particular kind of trust in place would be beneficial for you and for your family. And another thing that I wanted to mention that I did not get to mention previously, that a lot of folks think about estate planning, that it's just for the wealthy folks, and it really isn't. It really is a matter of just, it's for everyone. It's, even if you're 18 years old, you need to have at least certain documents in place, be it at least an advanced healthcare directive and a power of attorney. And estate planning is not about wealth, it's about your legacy. And legacy does not always equate to money. Estate planning can also be leaving memories for your family and for your children, writing your stories to them. I mean, there could have been certain events or heirlooms and things of that nature that are of such great importance to different families. And it's important for the younger generation to be cognizant and aware of all of those particular important aspects of their heritage and their family as well. So thinking about estate planning narrowly and thinking about it as just a will is definitely very limited. And I think we should open our minds to view it in such a broader light, because it actually is much broader than what we ordinarily think of it as. So, and that actually, let me see if I have any additional questions here. Okay, and I am actually out of questions. So just to reiterate, my name is Attorney Tanika Thompson Mungo, and my office is in McDonough, Georgia. Our address is 390 Racetrack Road in McDonough, Georgia, and we assist families with estate planning and probate and administration. Our magic statement, as I like to call it, is that we help families and individuals plan for and protect their legacies. So if you are in need of these kinds of services, please do not hesitate to at least contact our office and schedule an appointment. We would love to meet with you to see how we can help you plan for and protect your legacies. I thank you all so much for participating today. This was a wonderful presentation, and we look forward to having more events like this in the future. In light of COVID, it has been such a challenge to be able to connect with people. So we actually look forward to these events when we're able to put them on, so that we can at least spread the word with those in our community about the importance of estate planning. If you do need anything after our event today, please do not hesitate to reach out to our office. The number is 678-855-6002. And we look forward to hearing from you. Thank you again so much for attending.